Good day to you, and welcome to another Paddocks Club video tutorial. Today I'm going to take you through Sectional Title Building Defects 101. I'm going to start talking of the general rules in regard to building defects, move on to the exceptions to that general rules, touch on structural defects, and then deal with construction or developers defects. Let's have a look at the general rules. Firstly, insofar as sections are concerned, an owner repairs and pays. When it comes to those parts of the common property which are not subject to exclusive use rights, unregulated common property, the body corporate carries out the repairs and pays the cost. When it comes to common property that is subject to exclusive use, the body corporate must carry out the repair and recover the cost from the owners who holds rights. As you know, in practice, quite often the body corporate will make arrangements with owners that they carry out their own repairs. So that means the body corporate doesn't have to repair the areas subject to exclusive use rights in certain schemes. But the fundamental legal obligation is on the body corporate. Then let's look at the exceptions to those rules. Firstly, common pipes, wires, cables and ducts in sections. Although those are part of the sections, and it sounds as if the body corporate should not be involved, because they're common, the body corporate must repair and maintain those. When it comes to hot water cylinders on common property, even though they're part of the common property and it seems the body corporate should repair them, the owners who are served by a hot water cylinder and its entire installation must both pay for and carry out the repairs to those hot water cylinders. Let's look at structural defects. The Act makes no distinction between parts of a building that are structurally significant and those that aren't. The only distinction is between sections and common property, and the fact that some of the common property may be subject to exclusive use rights. Now, there is an argument that the reciprocal servitudes set out in the Act give rise to an obligation on the body corporate to fix any part of a section that is structurally significant. I don't agree with this argument, and as far as I'm concerned, when somebody says, no, I don't want to pay for this, I think the body corporate should, because it is an integral part of the structure, and therefore the body corporate should pay. I don't think there's any basis in the Sectional Titles Act that supports that argument, but you will often hear it. Another thing that comes up often is the issue of whose fault is it that the defect is there? And most particularly, no, I'm not going to pay because this is a construction defect, or this is a problem that arose from the fact that the developer didn't develop the scheme properly and it didn't do the work properly, and therefore I don't feel I should pay, I feel the body corporate should pay. Well, the fact of the matter is that's also a bad argument. The body corporate doesn't contract with the developer or any of its subcontractors. The owners do that. The body corporate may have a claim against the developer, but the fact of the matter is that it needs a special resolution to sue, so you need to be worried about that. Development companies are usually set up as special purpose vehicles, and they seldom have assets that can be attached. But if the defects are found soon enough, the developer company may still own units in the scheme. And then those and any future development rights that it holds can serve as security for a claim. Now, the managing agent may be loyal to the developer. It might be a related company or a managing agent with an ongoing relationship with the developer. So that's another red flag, something you should be worried about. If you think that the body corporate may have a claim against the developer and it is possible to achieve the required special resolution, then the owners or the trustees in that situation should consult an attorney. Especially if this is done early, it can result in the developer returning and repairing the problem. But as time passes, the chances of a successful claim against the developer do reduce considerably. So the idea that you should watch carefully and approach this issue as soon as the defects become possible is very important. The possibility of a claim against the developer, even if it exists, does not excuse the body corporate or an owner from the statutory obligation to repair and maintain, because that's in the Act. So the statement, but this is not my problem, the developer caused it and we have a claim against the developer, is not correct. You still, if you are the body corporate and it's a common property, issue that isn't covered by one of the exceptions, that's the hot water cylinder, the body corporate has to do the work. Equally, if the problem is in the section, then the owner must do the work. And if it is a part of the common property which is subject to exclusive use rights, so often this happens with a balcony, for example. It's leaking and the owner says, no, but it's not my problem, it's a developer's problem. That really is not. The fundamental situation is that the body corporate must do the work and it must recover the costs from that owner. It may be that the body corporate or the owner has a claim against the developer, but that doesn't mean that the work shouldn't be done in the first instance by the person who is primarily responsible. Thank you for joining me. If you have any questions, let's deal with them in the discussion forum.